Reclaiming my time, if I might. This at one time had been a legitimate investigation, something that this committee should do, and we have generally done in the past with consent of all the parties on both sides of the aisle. It's painful to sit here and watch it turn into a partisan political theater, and unnecessary that it move in that direction. We made a promise to the Terry family that we were going to identify what went wrong, and we were going to ensure that it didn't happen again. We've gone a long way, I think, in identifying what went wrong, and I think that that's something that we can all be proud of, or at least think that we did our job. Somebody mentioned earlier patience, the patience that the committee had gone on this, but I do want to know that some 7,600 documents have been provided to the committee. They showed that the gun walking began in the Phoenix Field Division of the ATF in 2006, and that senior officials in the Department of Justice didn't know that this tactic was used in Operation Fast and Furious until 2011. Now, there were 4 of these operations. 3 of them happened under the previous administration. We asked that Attorney General McCasey be allowed to testify because apparently he was briefed on that matter. He was not allowed to testify. That went by the by. There were other people at the ATF, acting authorities, who were going to testify that this administration, the Attorney General and others above, had not been informed, and he wasn't allowed to testify. Yet this committee then issued a subpoena, and it wanted information that it was illegal for the Attorney General to share, that would have compromised ongoing criminal prosecutions and investigations. They wanted information that was prohibited from disclosure by Federal law or that was currently under seal by a Federal judge. It wanted the production of grand jury documents and other Federal law things that were prohibited for the Attorney General to turn over. It wanted documents related to active and ongoing criminal investigations that would jeopardize those prosecutions. And it wanted detailed information related to confidential informants, highly sensitive information that would endanger the lives and the lives of their families. So that's the patience, I guess, that was referred to earlier, that people were seeking all those documents that never should have been produced. And it wasn't until last Friday night that the Chairman finally recognized that this was unprecedented and contrary to the rule of law and withdrew those requirements. But then he came and moved the goalpost and had a whole new updated citation, and now we look at what's left to fight over here. Apparently, we're left to fight about an explanation of how the Department came to learn that its original denial that this gun walking had occurred was inaccurate, which it now has acknowledged, and why they later changed course and admitted their error. So there's nothing in this remaining set that have anything to do with how gun walking happened and how it's going to be reformed. That's what we promised the family, to find out how it happened, which we've done, and then we promised them reform, which we're not doing. And when we tried to do that, if we can recall during the hearings, there was an effort made to question witnesses about the failure of the current laws to combat gun trafficking, and the Chairman cut those questions off, specifically told the agents not to answer those questions, said it was outside the scope of the hearing and that it wouldn't be considered valid testimony. And so it seems to me that we took reform off the table before we even got started. I think that's an injustice to the committee's work, but more particularly to the family and to the American public on that. This is a narrow set of new objects that this committee is apparently after from the Attorney General. He has said that he will provide those documents that he can and that he will work with the committee on that. There is a duty in the Constitution to accommodate each other, the executive branch and the legislative branch. It seems to me that since the goalposts have been moved yet again, since the Chairman had been wrong in so many of the earlier matters that he sought and now agrees that he cannot and should not get, that there could be an accommodation made to commit to good faith. That's all the Attorney General apparently asked for, was that the Chairman commit to a good faith conclusion of these contempt hearings if he produced the documents and explanations that went on. I would just hope that we would get back to a little sense of what this committee is about, accept that accommodation for now. You don't lose your chance to go after contempt if it doesn't work, and then pivot and have this committee do the rest of its job. We've done the oversight part. We know what happened. Let's do the reform part, make sure that it doesn't happen again.
Would the gentleman yield?
You have 4 seconds. Go right ahead.
I'd ask unanimous consent the gentleman have an additional 30 seconds. Would the gentleman yield? Pursuant to the statement that you referred to about Attorney General Michael McCasey, it has now been retracted from the testimony of Attorney General Eric Holder, where he claimed that his predecessor, then Attorney General McCasey, had been briefed about gun walking in Operation Wide Receiver. Now the Department is retracting that statement and claiming Holder inadvertently made the claim to the committee.
Well, I reclaim my time. It would be wonderful if we had him come in here as a witness and found out what the actual matters were, what the facts were. We shouldn't be predetermining them. The idea of asking for the testimony in that case was to find out what it actually was. There's no reason why he shouldn't be allowed to testify and why Mr. Mailman shouldn't be allowed to testify about who knew what, when, and where. We're not afraid to have the information come out. We just want the people to testify. But now moving on and knowing what happened in this case, let's do the rest of the job. Let's get to reform.
I appreciate it, gentlemen, and I take note of his comments.